Or almost good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your questions. So go ahead, start putting your questions in the comments. I will answer. As soon as I'm finished with this good topic that I have for you today, and it's getting the interview waived for the marriage based green card. Yes, that is happening. Yes, it is possible. We just got one in this week. Our clients were elated to get that. Um, it does mean that you have to put extra effort into presenting a good application. I'll tell you the biggest mistake that I see going into the marriage-based process is the application is sloppy. And when the application is sloppy, then they have more questions. And when they have more questions, it means that they're going to call you in for that interview. When you present a solid application, solid petition with the right evidence, the correct information, that is when they will waive that interview. And instead, you'll get that nice surprise of getting notification that your green card will come in the mail, that you've been approved and your green card will come in the mail shortly. So keep in mind that you have to present a strong application, and that's what I advocate for. I find that individuals who come to me frustrated about the process because they got started usually with some person that says they do immigration, tax, and everything under the sun. They do the process with somebody like that, or they do it on their own. And then they find that the process is taking longer, that they're getting letters from immigration saying that they need to submit this or that. And the process that's supposed to be a few months to a year turns into a 2-year process and onwards. So what you should not be doing is you should not be preparing the petition and saying, oh, if they want additional information, I'll send it later. And if someone is telling you, just go ahead, file the bare minimum, and then they'll ask you for your information later and you give it to them at the interview, then you need to be skeptical about the expertise of this individual and whether this person is adding value to you in this process, or they're doing more harm to you. Because that's where I find things can go wrong, is when you're depending on the interview to provide additional information, or you're depending on the immigration service to then conveniently send you information, a request for additional information that you can always send later. That is going to be a recipe for further delays in your process. So my tip of the day is make sure that you are submitting the best application possible at the forefront of your process, and that you're not preparing to send the things in later on, because that means delays. Once they're asking you for additional information, it means that you will be looking at a possible 3-month delay for every time, minimum of 3 months, every time that you have to send additional information in. Because remember, it takes them time to review it, takes them time to process the information, and then to determine whether they're going to move forward in your process or what they're going to do. So you want to save yourself time, and you want to save yourself the misery of having to deal with delays like that, right? So that's what we do for our clients, for our couple clients, is we represent our clients throughout the process. We do not do a type of partial thing where we fill out some paperwork and then we send them on their way and say good luck, because that also is a recipe for disaster. Usually you'll have these types of people that do this sort of thing. They'll be like, we do immigration, and they'll sit down, and then some of them will be kind enough to tell you they're not attorneys. Some of them will represent themselves as attorneys or paralegals. and then they will say they're gonna just fill out this paperwork and they'll file it and they charge you what you may find to be a very reasonable amount. And then when you have further questions, they're not there to answer those questions. Or I've seen this where they're like, oh boy, you need a lawyer for that. I've seen that where you go back to that same person and then they're now they're now telling you that, oh, yeah, that's going to definitely require a lawyer. You need to go to a lawyer for that. I can't help you with that. And usually that means that you're already in the mess. It means that it's going to be more expensive. And sometimes, in some cases, sometimes I have to decline cases when they have already, the mess has already been done, everything has already hit the fan, and it's going to be a lot more complex. In some cases, I do decline it for liability reasons. So, start from the forefront, plan ahead, make sure that you have an attorney who is going to be there for you, who is going to advocate for you, who is going to put their best foot forward at the beginning of the process, and they're not going to leave you hanging. All right. You can always give me a call to first we schedule an appointment to make sure that you're a good fit for the firm, and I'm sure you want to make sure that I'm a good fit for you, and then we can move forward very quickly. Fees are going up in March. That's another thing. Fees are going up, and when those fees, it's going to be significant, and significant increase for adjustment of status, for this type of adjustment of status. So you want to make sure that you get ahead of that. We will need time to get your petition together, to get it filed and get it in before the fee hikes. It's happening in around March. So get on it. Don't wait. Don't procrastinate. Get the information you need, get the advice you need, and then get moving on your matter. All right, so I'm going to answer questions now. So put those questions in the comments and I will answer. Hi there, Miss Virgo. So nice to see you. All right, so even if you file on your own, can you take over? So we can definitely discuss it. In cases where your application has already been filed, I would want to understand where you are in the process, what has transpired, and advise you, and then we can move forward from there. So I'm always here to assist. You can always call, schedule a consultation first. Schedule a consultation first, and then we can move forward. All right, let's see. Keep putting those questions in the comments. I'm here to answer, so put those questions in the comments. All right, I'm seeing a lot of questions, so hang tight while I go through them. Okay. So if my spouse is living abroad, can the interview still be waived, or the person has to be in the state? So they're waiving interviews here in the United States. They're less inclined to do that in the country abroad. That is going to be very rare for them to waive the interview at that point. But when they're in the United States, as long as they have all they need to move forward, they are waiving them in the United States. Now, it's where the officer is going to waive the interview is where they are sure, based on the review of the petition, that this is a bona fide marriage. Now, if they call you for an interview, it does not mean that you're denied or so there's going to be a major complication. It just means that they want to see you, they want to see you as a couple, and they may have additional questions to follow up on before they make the final decision. So I would say don't panic, because you never know what follow-up questions the officer is going to have. But the best chance to get your interview waived is going to be to put your best foot forward at the beginning. Make sure you submit a thorough application. Don't have the attitude that you're going to learn what they need along the way, that they're going to help and they're going to send you requests for information they need. Because that may not be the case. And even if that's the case, it will be delayed. And then going into the interview, when you've submitted an application that's skeletal, that doesn't have a lot of documents to support your position, or that your spouse qualifies, the officer can approach you with more skepticism, which means that if anything goes wrong in the interview, everything can go south instead. So, put your best foot forward. All right. If you get your USCIS receipt number for VAWA, how long does it take to get a response? So the first step is, after you've applied for VAWA, you get the receipt notice. Then the next step is going to be possibly the prima facie determination letter or the biometrics. So I've seen the biometrics first so far. That's been the pattern. The biometrics is for the background check. That has been scheduled within a month or two after the receipt notice has been issued. After the biometrics is done, around month 3 or month 3 to 6 is when we see the prima facie determination letter. That's basically saying, based on everything they have reviewed, they believe you qualify. It's just that they're going to review your case more thoroughly, and they want to give you this prima facie determination letter to seek possible public benefits, should you require anything like that, and should the state offer it. After that, usually between 6 to 12 months, if you have applied for adjustment of status at the same time that you've applied for VAWA, you will be able to get your work permit. And then the work permit that they're issuing is 2 years now. And if you've applied for a travel document that allows you to travel outside of the US if necessary, that's also 2 years. And then the decision comes. So multiple steps, but after the receipt notice is usually the biometrics. Keep those questions coming. I'm here to answer. So just got requests for evidence for my medical, but no interview appointment. They request that it's sent by mail. Does that mean my interview is waived? Absolutely, that could be a possibility. Usually when they're just asking for that one thing, it does mean that they may very well waive that interview. But I don't know your case. I'm not the attorney, so I wouldn't be able to confirm for sure. But if that's the last thing that they need to make a decision, then you definitely have a shot. All right, keep those questions coming. You're welcome. All right. So I'm going to tell you how to get in touch with me. You can go to the link in the profile, and it's going to bring you to the website, so Linktree, where you'll have everything you need to get started. You'll even have a button to schedule your own appointment. And then you can also go to the website where you can get assistance from the scheduling coordinators to schedule your consultation, so we can talk and get started right away should you qualify. So my fiance just got his green card. So fiance just got green card. Can I use my visitor's visa to stay in the US after we get married and file for adjustment of status? So that's a complex question, and I urge you to get legal advice. You should not be entering the country with a visitor's visa in order to stay. If you present that to an immigration officer, sure as anything, you'll be turned around. However, individuals who are here on their visitor's visa and their priority date is current, they are able to adjust status. Now, you would have to be married, and if the person is a US citizen or permanent resident, you would have to be married. And then there are certain concerns, right? If you enter with your visitor's visa right away, you get married, and then you get married and then you file the paperwork. That can also spell a disaster, because if you go to the interview, they can then red flag you for intent to come with a visitor's visa, intent to come as an immigrant with a visitor's visa, which can lead to all sorts of immigration charges. So you want to make sure you schedule a consultation and get legal advice about how you should approach this with your fiance. And going forward, you're going to get married. How should you move forward there? So it's a complex question here, but it is possible for individuals to adjust status with their visa here in the United States, but the circumstances have to be right. Good afternoon. I have a question. If you did a biometrics for undocumented child, what's next after the biometrics? It's going to depend on what the case is. What's the case type? Is it VAWA? If it's VAWA, then that means that after the biometrics, then the child may get a prima facie determination letter next, and it depends on all the other benefits that the child applied for. For example, did they apply for the work permit as identification? Of course not, as permission to work. And did they apply for a travel document? So it's going to depend on what case type. Is it SIJS, where they're a special immigrant? So it's going to depend, because remember, this is not a one size fits all process. Are the processing times on the website usually accurate? So there are a range, right, from the least amount of time to the longest time, but it doesn't mean that yours is going to take the longest time. It means that right now, all the applications are being processed in that time range. So I would say that they're not necessarily accurate, in that yours may not take 36 months. So, for example, it may say adjustment of status is taking 36 months. Yours may not be with that timeline. My clients have gotten theirs in 5 months. So in as little as 5 months, they've gotten it. Doesn't mean everybody's going to get it in 5 months, but some people are getting it in that short of time. And then some people, usually where I find it takes that long is where, of course, I mentioned it before, where they didn't submit a good application, and now their request for evidence. Maybe they went to the interview and the officer wasn't convinced. And so now things are taking longer. They're going through extra security clearances and investigations. So, they may take a longer time because of that. So I would say it's an estimated time range. So, does your office work with, I'm assuming, with someone that has a work and travel program? So it depends on if it's immigration related, then definitely we can work with you. But first, we have to start that consultation to determine what your needs are. My question is, if a mother is married to a US citizen, uh, can her daughter be part of the filing whose age is 33? No. If your dad is permanent resident and if wife is a citizen, can they both file for his husband's child over 18 and the child is living in the state? So under immigration law, children are under 21. If the if if the child, it's whether the citizen is going to apply for the stepchild is going to depend on, did they get married, before the child was 18. If so, then it is possible. But if the child is out of status, that can also be a problem. So your question is it's a little complex because there are a lot of moving parts going on here, and this is where the consultation is going to be important. But both a permanent resident and a citizen can sponsor a child and a stepchild. When the citizen can sponsor their stepchild, if the stepchild is under, if got married, so the parents got married before the child turned 18 and they're still under 21, then they're living in the state, they can go ahead and sponsor them and go through adjustment of status. The permanent resident, now if they're out of status, there's going to be a more complex process through a waiver to get forgiveness for the overstay before they can get permanent residence. So this is where I'm saying schedule that consultation because it's more complex, and make sure that you do that so you're covered. I came here pregnant as someone else. My daughter is now 21. Can she file for me even though I entered someone else's name? So this is a good question. And you need to make sure you get legal advice. You can always call, schedule a consultation. We can definitely assist you with advising you on how to move forward. While I can't give you particular legal advice, because remember, this show is for general information, it's not personalized legal advice. I'm going to give you a bit of general information that will give you an idea of what the possibilities are, but definitely schedule that consultation. The number is right on the screen, so you can go ahead, call, and a scheduling coordinator will be more than happy to assist you. Now for the answer. Yes, adjustment of status is possible as long as the daughter is a U.S. citizen. They are age 21 or over. But if they came in and there's evidence showing that they came in using this passport, then the next thing would be, one, if it was using someone else's passport, what was the status of the person? Were they a citizen? Because then that means that there is going to be maybe an issue with claiming false citizenship, right? False claim to U.S. citizenship, which there's no waiver available for, and it's a permanent bar. But if you were coming in as say, just someone else who wasn't a citizen, a resident, or someone who was coming in on a tourist visa, then in that case, it may be possible to adjust status here and then seek a waiver at the same time for misrepresentation or fraud. Because when you do submit a false passport to enter the country, that means that there was some under immigration law, it's not criminal, it's more of a civil immigration matter, but under immigration law you would need the waiver. So we do take cases like this and we do assist our clients to move ahead. So definitely get in touch with us. Is it true that Nashville, Tennessee is one of the states that takes long to get a green card? So it's not necessarily the state, but it's the service center, because there are service centers that processes your case, and then of course it goes to the field office. If your case is taking long, it means that there may be an issue pending. They may have additional questions. So that may be the issue there. But, I have not seen a general pattern where it just takes long in one location. Usually, if you're going through this adjustment of status process, and your case is going over a year and a half, approaching 2 years, then that's pushing it. That's long, and it may be something in particular with your situation. So I'm living in New York. Can I file for my green card in Florida? So you can, no matter where you are living in the United States, you can file for your permanent residence because there are designated service centers that accept your filing. So if you're living in Florida, doesn't mean you're going to file in Florida. You may file in Illinois at the service center there. And that's exactly why we're able to assist clients all over the country and around the world, because we do have to work with the USCIS offices, immigration courts. I have to work with the US embassies all around the world and the country. So I'm not limited by state lines or borders for this very reason, that when you're filing, might very well be filing in another state. How much is your consultation? It's $150 for up to an hour. Who can be your affidavit of support apart from your spouse, and what are the requirements for that? So anybody who, as long as they have legal status here in the United States, can be, so an acquaintance, a friend, a family member can serve as the sponsor. If you were barred from the US for 5 years because trying to work in the US, how can you be reinstated with a visa after the 5 years? So it's going to depend, right? So if you were barred just for 5 years and then the 5 years have passed, it means that you're not necessarily inadmissible anymore. However, what it means though is that they're never forget. They will never forget this. And immigration is sort of like this, where they may forgive you in the future, but they will never forget, right? So in your case, when you're trying to get a visa again, they are going to remember that, and they're going to, you really have to earn their trust again. You have to be able to show real good evidence why you wouldn't repeat the same violation again. And it's very hard to do that. I'll be completely straight up with you. It's very hard to do that. It doesn't mean it's impossible, but you have to definitely, come very good with your application. Is there a waiver for an immigrant who used their SSN to work in and place citizen in a W-4? So false claim to US citizenship is one of the worst violations under immigration law, and it comes with very few waivers. There are waivers available. For example, if you are seeking asylum, that could be a possibility. If you are applying for certain humanitarian relief, even with T status, that may be a possibility as a victim of trafficking. If you were at, under a certain age and you honestly believe that you are a citizen, this usually happens where maybe the person came across the border when they were very young, and their parents are citizens, but maybe they aren't. Then that could also be a basis to get a waiver. So it's going to depend on the circumstances. Can we do this if we already have an I-601A waiver? So if it depends. So if you are applying for an I-601A waiver, my assumption would be that you don't qualify for adjustment of status. However, give me a call if you are not already represented by an attorney. You can always give me a call to do a consultation to determine whether you may qualify for adjustment of status. But if you are represented by an attorney, by all means, make sure you defer to your attorney who is representing you, who has already given you the advice. Because remember, this is general information. I'm not giving you personalized legal advice. And the legal advice that you will get in the consultation may be very different from the information that you're getting here, because at the consultation, I'm then getting more specific information from you that will help me to determine whether you qualify for a benefit or another benefit, or a completely different benefit than what I have talked about today. All right, that's going to be it for me today. Thanks so much, everyone, for joining me. I will be back tomorrow with another good topic, and you can always come with your questions. Just put them in the comments, and I will answer. So thanks again. Have a great evening. Bye bye.